What the? What the fucking? Gah! Thank you for. Sorry for my outbursts. I admittedly forgot that I was live. The WebEx meeting went live, and then all of a sudden just ended. Or I got... Okay. They stopped it. I don't know what is going on today. I really don't know what their game plan is. It's 2:30 in the afternoon. I am so confused. Yeah, it was up for a few minutes. There was a clerk that was logged in, and then all of a sudden I just got kicked and the event status went back to not started. Oh, yes, Yuki, I see you. Yes, Yuki, you do exist. Yes, you're a cat. Yeah, that's the same thing that I had. It said the event was started. I went to log in. It didn't connect to my normal WebEx system. It made me like install a Chrome extension that I wasn't planning, so that delayed me. I got in. I got the stream set up. It was me and the panel host, which is, the court clerk usually is the one that's running the cameras and WebEx and everything, and then just got kicked out and got event has ended. Fine. You want to say hi to everyone? One of my cats, Yuki, who is being a complete brat today. Actually, she's been pretty good most of the day. Just all of a sudden, she wants attention. It can't have anything to do with the fact that I'm trying to work, can it? Hmm? Hi. So yeah, I just, keep kind of refresh periodically, because if it comes back, hopefully I have everything set up for it now. No, you're not getting on the desk. Okay, now we've got it started again. So okay. Well, there's a Q&A section, so I'm going to queue and hope to get an A. Yeah, that's going to be my plan, is if Mr. Keenan here responds back that they're not actually doing trial stuff today, or hits 4 o'clock or probably 3:30, I would give up. But that's okay. Oh, Courtroom 11A. Okay. So it looks like they okay. No, I do want this one on the stage. I want the host off the stage. Okay, so that is the defense side. That is Mr. Swinney in the middle. Mr. Westover is the one closest to the camera. And his assistant, I am not remembering her name right now. Looks like they blocked off all of the benches on the defense's side of the gallery to make sure that no one from the jury sits there, so that we make sure that they stay off the camera. They are being very careful with the cameras and the jury for protection. They're only referring to the jurors by number instead of by name. They're pushing really hard to make sure that we don't see any of them. Oh wow. I did not expect to see Mr. Westover and Mr. Swinney are both unmasked right now. That has not happened in the trial or in the hearings usually. I'm just working to get as much screen as I can here. Okay. So, for those unfamiliar, the courtrooms now have 2 TV screens. The one that is closest to the judge, who is just off camera on my side of the screen, that one they use for the WebEx video conferencing. Basically, if they have a witness or a lawyer or someone that's appearing remotely, they'll have video up there. The other screen right over the defense's table is wired into the desks so that the attorneys can plug in laptops and use the monitor to play video and audio and such. Chances are that means that when they play video evidence, and we know there's going to be a significant amount of that, we're not going to see it full screen. We're only going to see what's on the TV, so... would be logged out of there, wouldn't I? Okay, the first lawyer who came in was Mr. Vasquez. That is the deputy district attorney. I am not remembering the name of his assistant, unfortunately. As far as a lack of audio, I think they're going to keep the audio off until they actually go on the record. That way, if there's conversations in the background, like between jury members or defense talking to each other, that we don't hear that and get inappropriate information. Oh, wow. Uh-huh. Okay. I think I like this view a little bit better. And again, he's just dialing it in to get the jury box out. That is Judge Moad. I'm not... she was just being body double, maybe. They went on the record, but I don't seem to have audio yet. Oh, hey, Halo Space. Yeah, I'm using the stream from WebEx. Um, I just can't tell. By all accounts, they have not turned on the audio on their end, even though they're on the record. Yeah, Mr. Vasquez is poking around on his phone. They're not actually starting yet. I actually, I tried swapping it over to my headset just to check. Actually, I have another thing I can try to do. Yeah, I'm not using the MOTU right now, um, but I did a similar test yesterday, and it did work perfectly fine. Okay, yeah. Yeah, so I just called in and I'm not hearing anything on the call-in phone number. So I think they do just have the audio off. Maybe. But yeah, this is the WebEx is configured to go to one of my virtual patch cables, and then that's going straight into OBS. And it's not muted at its full volume. I wanted to isolate it from the desktop just so that I don't have like email notifications going off or whatever. Switch audio. Oh, they're back off the record. They might have been doing tests. But, yeah. I have confirmed. Use computer audio. I'm back on camera. Yeah. Okay, so yeah. I called out, or had them call me, so, and did it the most perfect way I could, and it still didn't come through, so it is not on my end. Thanks. It's every time I find out I missed one of these hearings, I kind of kick myself, and now I'm just like so jittery because it's all built up to this. No clue who that is. No, I am logged in. Good. Okay. Now, I'm going to try something here really quick, just to confirm the sound. Let's see, here's Spotify. Continue. Curiosity, is anyone able to hear music? Wait a second. Yeah, I'm noticing how you got the capture. Audio input capture, is this the one I want? Now I think you will. Oh. Okay, I'm thinking this is the... I'm turning off the video for just a moment because they seem to be having jurors going through the main courtroom, and they're not supposed to. As far as the music, good. So I did have an error on my end with the audio routing. It is set up correctly now. Cable input on one end and output on the other. Impressive. Yeah, it does seem like there's I got the name Schweitzer sounds familiar for the person who's been filing some of this paperwork on Vasquez's behalf. Yeah, there was a Ride C. Schweitzer filed the last motion. And when I think about it, I can look at who's the attorney on record. Yep. Mr. Schweitzer is his assistant. And Mega Desai is Mr. Westover's assistant. Okay. I'm going to go ahead and turn the video back on, and, you know, if people are jumping in front of the camera, that's the court's fault.
Jury instructions.
There we go.
The judge explains the law that applies to the particular charges in the case.
So this is jury instructions at this point.
The state must prove beyond a reasonable doubt for a guilty verdict. You will receive a printed copy of those instructions. 6 is closing arguments. This is when the attorneys have the opportunity to persuade you how to decide the case. 7 is deliberations, when you will go back into the jury room and decide whether the defendant is guilty or not guilty of any particular charge. And 8, return of verdict, when you tell us your verdict. I will explain in a moment what is and what is not evidence. It is extremely important that you consider only the evidence in deciding the facts. Do not allow any personal feelings, sympathy, prejudice, or bias, whether conscious or unconscious, to influence your decision making. You must not be biased in favor of or against any party, witness, or lawyer because of the person's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, socioeconomic status, or political affiliation. As part of your orientation, you were shown a video on unconscious bias. Unconscious bias is a term used by social scientists to describe the reality that everyone, including me, has feelings, assumptions, perceptions, fears, and stereotypes, that is, unconscious biases, that we may not be aware of. These hidden thoughts can affect what we see and hear, how we remember what we see and hear, how we interact with others, and how we make important decisions. Our biases can affect how we act, favorably or unfavorably, towards someone. You should make every effort to be aware of your unconscious biases and what effect those may have on your decision making. As a judge, I am the gatekeeper regarding evidence. I determine what the law allows to be evidence. In effect, the law considers anything that is not evidence to be unreliable. That is why you may not consider non-evidence in deciding the fact. However, the law does not conclude that anything that is evidence is necessarily reliable. Determining the reliability or believability of evidence is ultimately your responsibility. You must decide what evidence is believable and how believable or persuasive any particular piece of evidence is. So, while you are not allowed to consider anything that is not evidence in deciding the facts, you are free to decide how believable or unbelievable, important or unimportant any particular piece of evidence is in deciding the facts. Evidence consists of testimony of witnesses and exhibits that are admitted into evidence. Testimony is what a witness who has sworn or affirmed to answer questions truthfully says while being examined as a witness. Exhibits are physical objects such as photographs, charts, and letters. You will be able to examine admitted exhibits during your deliberations. You may draw reasonable inferences from the evidence, but do not guess or speculate. In understanding what is evidence, it is helpful to have some examples of what is not evidence. The fact that a criminal charge has been filed against the defendant is not evidence. Any defendant is innocent of any crime unless and until the state proves the defendant's guilt beyond a reasonable doubt. Questions from lawyers, or other non-witnesses for that matter, are not evidence. So, whenever I sustain an objection to a question, do not speculate about why the question was asked or what the answer would have been. This is a subtle but important point. In our everyday lives, if a friend asks us if we have seen our mutual friend's new car, we infer from the question that the mutual friend has a new car. However, it is not the same at trial. The person asking the question is not a witness and is not subject to the safeguards that the law requires before you may consider the person's words as evidence. So, in court, you are not allowed to consider questions asked by attorneys or non-witnesses in determining what the facts are, because those questions are not evidence. Of course, when a witness answers a question, you may consider the answer in the context of the question. For example, if a lawyer asks, was the traffic light red or green, and the witness answers green, you may take the answer as stating that the traffic light was there and that it was green. However, if the witness answers there was no traffic light, you may not take the question, the initial question, as evidence that there was a traffic light. From time to time, a lawyer may object to something that is offered into evidence. I will decide whether the objected to material will be admitted into evidence. If I overrule the objection, the material, for example, an exhibit or a witness's answer to a question, becomes evidence. If I sustain the objection, the exhibit is not admitted and is not evidence, or the witness is not allowed to answer the question. If the witness starts to answer a question before I sustain an objection to the question, you must disregard the witness's response because the response is not evidence. Occasionally, I may decide that something that had been admitted into evidence should not have been. If that happens, I will instruct you to disregard the exhibit or testimony that should not have been admitted. This means that the material is no longer evidence. You must not consider it in any way. You must treat it as if the question had not been answered or the exhibit had not been received in the first place. You must not interpret any statement, ruling, or remark I make during this trial as any indication that I have formed any opinion about the facts or outcome of this case. You, and you alone, are to decide the facts. You must decide how believable the evidence is and what weight or value you will give that evidence. You may take notes, if you wish, during the trial, and we will provide you with notepads and pens to do that. However, if you do decide to keep notes, please keep in mind that each party is entitled to the considered decision of each juror. Therefore, during deliberation, you should not give undue weight to another juror's notes if those notes conflict with your notes or your recollection of the evidence. Do not allow your note-taking to interfere with your ability to observe and evaluate testimony. Your notes may be in only two places, the courtroom and the jury room. You may not take the notes with you on lunch or overnight breaks, for example. Mr. Keenan will make sure that your notes are safe and no one has access to them in your absence. Do not discuss this case during the trial with anyone, including any of the lawyers, the parties, witnesses, your friends, or members of your family. This includes not communicating with anyone by any other means, such as telephone, text messages, email, internet chat, blogs, or social networking websites. This is a really hard and awkward part too. Do not discuss the case with other jurors or look at the other jurors' notes until you begin your deliberations at the end of the case after you have heard all the evidence and the arguments of the lawyers and been instructed on the law that applies to the case. Each of you must keep an open mind throughout the trial and must not attempt to decide the case until you begin your deliberations. And I know that's really weird and hard that we're gonna put you in rooms with each other and you have one thing in common and it's this case, but you just cannot talk about it until you're deliberating because of all of these things that we've just discussed. We don't want you making up your mind ahead of time, okay? Do not make any independent personal investigation into any facts or locations connected with this case. Do not look up any information from any source. Do not communicate any private or special knowledge about any of the facts of this particular case to your fellow jurors. Decide the case only on the evidence received here in court. Do not read any news stories, listen to any radio or television reports, or read or listen to anything on the internet about this case or about anyone involved in this case. In addition to conventional research, you also must not use any internet search engine such as Google to look for any information about the case, the law that applies to the case, or the people involved in the case, including the defendant, the witnesses, the lawyers, or the judge. Do not use any map program or mapping system to attempt to view or locate any of the locations that may be discussed in the case. In short, do not communicate with anyone by any means concerning what you see or hear in the courtroom, and
keeping in mind, Multnomah County does not sequester jurors.
Other than what you learn
At the end of the day
the
of jury duty, they
Decide
go
the case
home and
only
have
on
their
what
normal
happens
life.
here
This is just a
in open
daytime
court,
job.
where both the state and the defense are aware of and have the opportunity to question the sources of the evidence and to address any legal issues that may arise. That is the only fair way to decide a case. If you base your verdict on anything other than what you learn in this courtroom, that could be grounds for a mistrial, which means that all of the work that you, your fellow jurors, the parties, the lawyers, and the judge have done would have to be done all over again. That is why this is so important. If you disobey any of my orders, you could be held in contempt of court. Ignore any attempted improper communication. If any person tries to communicate with you about this case, tell that person that you cannot discuss the case because you are a juror. If that person persists, simply walk away and report the incident to Mr. Keenan or the court. You may not talk to anyone about this case, even the people closest to you, except to say you are a juror on a criminal case and Judge Moad says you cannot talk about it. After you have rendered your verdict or have been otherwise discharged by me, you will be free to do any research you choose or to share your experiences with anyone you choose, either directly or through your favorite electronic means. Remember that all phones, laptops, and other electronic devices must be turned off while you are in court and while you are in deliberation. We'll talk about this. Some judges do collect such devices from you during deliberations. We'll talk about that. But we do this in part to prevent anyone from questioning whether you are engaging in improper communications during deliberations. As I said, again, tomorrow morning we will hear the opening statements in which the lawyers will outline the evidence as they expect it to be. After the opening statements, the evidence will be presented. At the conclusion of the evidence, I will instruct you about the law that applies to this case. The lawyers will then make their closing arguments to you, and once they are finished, you will begin your deliberation. At the end of the trial, you will have to make your decision based on what you recall of the evidence. You will not have a written transcript or recording to consult. That's why I urge you now to pay close attention to all of the testimony as it is given. If at any time you cannot hear a question or answer, let me know immediately by raising your hand. In performing your role, you must, of course, be fair and impartial. You must follow the law whether you agree with it completely or not, and you must not allow yourself to be influenced at all by personal feelings, sympathy for, or prejudice against anyone involved in the case. So with that, we will turn the camera down. We will turn the camera down so that as you leave the courtroom, you will not be captured on the cameras. Oh, that's even better.
Yeah, up is better than
Mr.
down.
Keenan informs me there are a few questions about the trial still going to the jury by Friday. Are we still optimistic that the jury will be in deliberations on Friday?
Yes, sir.
All right. So we're still planning on this getting to you by Friday, and if you do need additional time to deliberate, we will address that on Friday. Okay, so feel free to head home for the night. We'll see you. Okay. Yes. I'm going to have Mr. Keenan give you a tour backstage and give you some passes. Now, these passes will get you into a staff-only door so that you can go in the
Yeah,
jury
judges do
deliberation
not
room.
like to talk about jury
We have
nullification.
2 deliberation rooms during the
And
pendency
that's a
of the
reason
trial, so
why
just
I
divide
would never
yourself
be a good
7
fit on
and
a
7,
jury.
and then go into those 2 separate rooms. Again, probably just pick the same room. every
CGP
time,
Gray
so there's
does an
no
amazing breakdown of how jury nullification works.
And 9 a.m. Well, yeah, 9 a.m. tomorrow. We'd like you in the room, ready to go, and then Mr. Keenan will come gather you up and bring you into the courtroom as soon as we are ready.
All right, so if everyone will come with me, this door.
Now, the alarm's probably going to chirp because that door is set to alarm if it's held open for 15 seconds. Nobody panic.
Apparently, they're not doing anything today. It sounds like they wanted to get all the preliminary stuff out of the way so that they can go fresh in the morning on opening arguments. That said, they want the jury in place at 9 a.m. The judge is going to be ready by 9:15. So.
Okay, yes.
The reference for jury nullification, it's a combination of judges expect the jury to prosecute according to the law. You know, they take the reading of the law and say, is this a crime under the law or not? But at the same time, you cannot penalize a juror, or you can't penalize a juror for saying something is against the law, or something is not against the law if it clearly is. And with double jeopardy, if you find someone innocent, even though there's overwhelming evidence that they're guilty, because of double jeopardy, they can't be tried again for the same crime. So it's a logical argument where evidence could say that somebody is that somebody is a guilty as heck, but the jury believes they shouldn't be prosecuted for it, so they will say that they are not guilty, and then they get away with it, and that's nullifying the jury. CGP Grey does a really great breakdown on YouTube about the process. As far as questions for Wi-Fi, they do have Wi-Fi. Also, if you have long distance on your phone, they have a phone number that you can call into and listen into the WebEx, just the audio itself. I have it linked on the website, but it's also on the court's website as well. Yep, fugitive slave laws was one of the big cases where that happened. Basically, the law said that captured slaves had to be returned to the South to their owners, but Northern abolitionists said this was a bad law, so they would nullify the jury and say, no, this person's innocent. Yes, yep, that guy exactly. He is an amazing, I mean, he's British, but he has amazing insight on the American political, judicial, a whole bunch of stuff, and it's, yeah, his work is just amazing. But yeah, at this point, I have a feeling they're just gonna, finish up talking among themselves, make arrangements to take Mr. Swinney back to Inverness for the night, and then, bring him back in the morning. I'm thinking about it. I mean, unless there's anything else, I'm thinking I might just go ahead and end the stream here at this point, since we know that there's not really anything else going on.
Adding, by the way, to the fun of this case, the West Box out.
It wasn't working for anybody all day.
Well, it's working now.
Great. Westlaw is a legal
It's a way to research cases.
database.
Oh, Westlaw was down. I have not had access to that, but I've heard other terms.
So I guess you guys tell me what order you want to.
I feel like we have some, I've got a big list of relatively simple ones, and
Okay.
perhaps I'll just read out on the record, start the first page or so of the,
And
Oh.
is this all, Ms. Desai emailed me at 1:42 a list, is this the list we're going off?
Oh, I guess they're going over evidence.
Defendant's motion and then motion.
Yep. These are the questions that were raised yesterday about potential evidence.
I mean, I guess first of all, make a motion to exclude witnesses.
There's no objection to that motion, and the observation rooms are going to have a sign on the door that says witnesses are excluded.
Does he agree that with the exception, of course, for victims?
Of course. And I believe that when I was asked, I said, except the victims. So
Yeah,
hopefully
and
that'll.
I understand the complaining witnesses feel the right to be present.
Okay.
So my motion is that I'll say that we've agreed to Megan Stewart. No evidence will be admitted about Megan Stewart receiving threats or filing a lawsuit. Agreed that nothing related to cyber charges will be admitted. Any events occurring at or around the Park Road after Mr. Britton was shot. Any reference to him becoming from Twitter profile or posts. Any testimony of being confirmed and received Simmons. Officer Brandon Holmes testifying in court about that interviewing parking lot. We're at our first successful motion here. We're asking statements of the person named Kodiak, 2 cases of telling
Okay.
One more. You come to agreement to discuss since that Mr. Britton will testify. Prior to that,
They're going over a list of evidence that they're not going to use. When they mentioned your name, it was talking about references to you filing your civil suit as well as the interactions from people of the public after.
and confrontation.
Well, okay, I guess let me just try to understand. Is why does Mr. Britton knowing Mr. Swinney's name? Why is that?
I mean, just to identify him. That's Mr. Schmidt.
So he'll come in. Presumably, Mr. Britton will testify. This is what happened to me on that day. Do you see the person here in the courtroom today who did that to you on that day? He'll say, presumably,
Yes.
it's someone here in this courtroom, and he'll point to that person. The fact that he knows the name of Mr. Swinney, and when he finds out the name, I mean, on the one hand, it seems relatively harmless to me as an effect on listener that someone else said, oh, that's Alan Swinney, who shot you in the face.
Yeah, and
On
they're
the
basically
other hand,
just
I don't
saying that
know
they're
how
not
you
going
would-
to use
Do
your
we have to ask the question?
filing a lawsuit as evidence against him.
You know, my anticipation is throughout the course of his testimony, he'll say things like, yeah, Alan Sweeney shot me, or, you know, just because he knows his name. And,
The fact that he knows his name seems like that comes in. How he knows his name, maybe. Does name have to be asked?
and one other big thing is, they've already stated that they're not making it into an issue.
Sure, I get it. I guess just, I mean, it seems like a de minimis issue to me, one way or the other, frankly.
De minimis being just legal jargon for bare
What
minimum.
harm are you trying to prevent?
We want to make sure, based on
based on, I mean, I don't want, I don't want statements to come in that are not admissible.
So, to the extent that Jason Britton might testify, Kodiak is the one who told me Swinney's name. I think that is not hearsay because I think it is offered to show the effect on the listener, not to prove the truth of a matter at issue.
I guess my problem is I don't know who Kodiak is.
Does anyone know who, besides Mr. Britton, know who Kodiak is?
Maybe Mr. Britton does, but I mean, but no, I do not know who Kodiak is. And again, I don't think this is a non-issue.
I mean, here's what I'm gonna say. Don't ask him the question, and who told you his name, right?
This is a lot of what I dealt with on
if
Friday.
in the midst of his testimony, he's like, and I didn't know who shot me, but Kodiak told me it was Swinney. I feel like that's effect on listener and an exception to the
Hearsay rule being
so, state won't
hearing
ask,
something from someone
but
else
also-
is normally not admissible in court, but there are exceptions. And it sounds like they're going to say this is one of
Okay.
them. Because it's not so
Witnesses
much what was said,
describing
it
what
was
is
the
happening
intent.
in a video. Is this all the videos, a particular video?
So it's my experience with, probably Mr. Vasquez, but it's my experience with this office is they'll play a video, and even though it's plain as day what's going on in the video, we go, okay, can you describe what's happening now? And if we're in a situation where there is somebody, we get in a situation where it's not the witness's perception of what they're seeing in the video that determines what's on the video, it's the insurance. And so putting it, it's like playing a game of telephone. I don't want any sort of comments on the evidence. I want the jury to see the thing. Now, if somebody can say, I'm not trying to be unreasonable here, somebody could say, you know, at a certain point I was shot by a paintball. Is that where it happened? Yeah. But this whole, okay, what's happening now in the video? What's happening now in the video? What's happening? I'm going to play 10 more seconds. Can you tell me what just happened? There's too much of a danger of editorialization and skewing the jury's perception of that video.
Are you planning on having people narrate the videos?
No, not to narrate, but I will ask to pause the video and ask questions. We'll be able to see this, but we can proceed.
So you're going to ask a witness, so for example, again, if you call, let's just, again, for Mr. Britton, we're picking on him today. If Mr. Britton is asked to watch a video, and I don't even know sitting here today if there is a video of Mr. Britton interacting with Mr. Swinney, but let's assume for the sake of today's discussion there
The
is.
judge has not watched.
So you'll say, is that you, Mr. Britton, on the video?
Yes, it's
The judge has not watched the video evidence because the IT department has to do extra checks on the media before she can access it.
But you could say, do you know where in the city you are in this video? And he could say, we're on 4th Avenue.
things of that nature, yes, that would be how I would anticipate the context would be. Am I going to ask him, can you tell me, are you walking down the street, or are you yelling at him here? I mean, that stuff's going to play in the game, so I'm not asking him to narrate that.
Okay, and I'll address the court. It's just there's, for example, one of the videos was shown to a witness at grand jury. That witness was not present when that video was shot, so there's no foundation at all. And the foundation that it was, is this an inaccurate video, an inaccurate depiction of the video that you watched from that day? I don't want people commenting if they don't have any actual knowledge of the context.
So I think where I feel like we're landing here is if the video involves an actual person who's on the stand at the time, that they may be asked questions to provide context about what was going on and what was in their mind at the time the video is being shot. If the person is, let's say, an officer who was responsible for downloading the video that is now being presented to the jury, and he or she was not present at the time of the incident itself, then we would just be playing the video without commentary.
With one exception.
Okay, what's the one exception?
Not playing the video and asking.
It looks like Mr. Vasquez was the one who handled the grand jury indictment.
I mean, I don't think there's any dispute about the route that was taken. Probably we can object to Mr. Vasquez's.
Okay. Well, I mean, you know, to the extent that Officer Combs can say, I've watched the videos and I agree that this is the route that was taken, I don't see that as problematic for the purposes of explaining to the jury how the map was drawn.
And I don't, in that questioning, intend to like play clips or do things like that. I'll ask them, you know, under certain remarks or things like that. That's all. I won't play the video itself. I'll just say, I know.
Okay. Next, any testimony indicating a witness believes Alan Swinney or anybody associated with him had an intent to commit violent acts.
Yeah, essentially what, you know, there's, again, statements in discovery saying, well, obviously they were down here to
Oh
do
yeah,
this.
I forgot you were there.
Anybody that was watching would know that they were down here to do this. That's speculation that is not appropriate for the jury.
Your Honor, what I would respond is saying that the witness's perceptions of what they observe, as long as it's not based on speculation, on what they see. If they see someone swinging a flagpole at someone else's head, they could say, yes, where I stood, he's swinging at his head, and he's trying to hit his head.
And that's quite different than anybody that saw that would think.
I agree. So I don't know, again, right, like I'm not privy to what you think the witnesses might say here. But I agree with the state that
Welcome to
if,
pretrial
it is
motions.
observed that an individual committed a violent act, that is different than we all knew these guys were coming downtown to cause problems, right? And I'm seeing Mr. Schweitzer nod in agreement that that would not be evidence that the state is intending to elicit. Is that right?
That's correct.
Okay.
And I would like that these rulings and these restrictions be communicated to their witnesses beforehand.
I have no reason to doubt that the state will not make every effort to communicate these rulings.
Sure. And to make it very important to these witnesses that if they think if they want to editorialize in certain ways that are prohibited, that's going to raise emotions. It's going to create a lot of matters.
I'm sure that Mr. Vasquez and Mr. Schweitzer will tell their witnesses how annoyed I would be if I had to deal with this.
Your Honor, they're practicing for 20 years.
Number 12. Jason Britton's medical record / diagnosis.
I think, again, this is one where I'm not trying to quibble at all. It's just, will Mr. Britton talk about his conditions, his medical needs, and things of that nature? They're his own personal things. Do I need him to come in and say, he certainly will testify that he lives on doctor. But am I gonna say, have him say, I was diagnosed with X? I don't do that. I'm gonna say, he will testify that he has vision. That's his own body condition.
I would agree.
I also would agree. I just want to make sure that it's abundantly clear that I don't hear from Mr. Britton, this is what my doctor told me.
So I think if he says something like, and the doctor told me to put ice on it and I did, that's probably still fine. If it's, he said I had a subdural hematoma as a result of the MRI that I underwent, I think that probably is verging onto inadmissible hearsay. Probably, unless the state has an argument to the contrary.
Not this time, Ross.
Okay. We good?
I've taken a note, thank you.
Like, if he says he told me to take Advil or he wrote me a prescription, I think that comes in.
I mean, you're the rule 10 out of 2 area as well.
No, I think it's probably effect on listener again. He told me to take Advil and I did. And it made it wrong.
I mean, there's a truth in there. The doctor believes I have pain, so they will engage in that.
I imagine. Okay, so Mr. Britton would probably first have to say, I told him that I was in pain and he told me to take Advil. I mean, we're kind of arguing in a vacuum here. I don't know what he's going to say. He's going to say he felt pain, I imagine, and that he has ongoing vision issues.
That's correct.
Okay. Any statement of Alan Swinney saying there's video of X, Y, or Z. I don't know.
So, Mr. Swinney, there's a recorded interview with Detective Jones in this case, so he's a witness. And during those interviews, Detective Jones was asking Mr. Swinney about what happened on the 2 days. At certain points, Mr. Swinney says there are videos showing X, Y, or Z. Those statements cannot come in because it leaves the jury wondering. In the event that we haven't been able to find those videos, it leaves the jury wondering, well, why isn't the defendant showing those videos? And it shifts the burden then onto us to have the jury querying why aren't we showing those videos?
Are you planning on any Mr.
I'm not sure because I'm not even sure what statements. It depends kind of on what they've written out like, hey, this part of the interview that says that they can look at it. Or if
this-
it's not, I can take a look at it. But it's not a lot of context here. That's why I remember the statement for information for the question. Because
This is
the videos
Friday all over again.
is that referring to a complaint from Detective Jones? And then you're saying that at some point was this the exact quote?
I mean, sure, I'll read you the exact one. It's in discovery.
Do you have a transcript of the interview?
Yes. Alan Swinney is saying, in response to Detective Jones' question that, Alan Swinney is responding to some questions, and he says some people were trying to attack some of the folks in our group, and they got maced as a result of that, and they even say on video that it's on video. They came up and they indiscernible. You can clearly see on video that they really completely. Right? I mean, if the jury then goes, well, yeah, he just said that in the interview. So where's that?
So there is you don't have the video.
I haven't been able to find that.
And this is about the 15th? Or is it the 20th?
About the 15th.
15th is like videotaped from beginning to end, so
So, no, there's not. The video that we've received begins at the end of the rally. And Alan is talking to Dr. Jones about what is happening during the flag vote.
okay, there's a little more context, that's helpful.
In discovery
So,
that they gave to me.
I understand, but they probably gave you a lot of discovery. So to the extent that we can pinpoint where in the discovery you are trying to have them not have their witnesses testify, that's very helpful.
This represents my frustration on how they deal with this.
Well, the boat has sailed, so let's just pinpoint where the discovery is. So are you finding in the transcript, Mr. Vassar, the issue?
I am not, but I will look into the transcript. Is that a defense transcript or is that one just?
I have this name.
So this is the issue. I don't have that. I have the CD where we provided in discovery, but when counsel tries to reference, you say this is what makes it so difficult. It's like give us a little hint of like, hey, it's on the CD and it's at this point. And I'd look at that and I'd be prepared per se, but we're not. Because we're playing this game of he has a transcript and he wants to come up with some vague thing, and that's the issue we're struggling with.
Okay. So I appreciate that everybody is frustrated about it.
I'm frustrated.
Also, this ship has sailed. So he is saying, well, I guess let's take a step back. Are you planning on putting Detective Jones on the stand and pushing play on the interview and playing the entire interview Detective Jones did of Mr. Smith?
That's a potential approach the state may take, yes.
Okay. So, I guess there are a couple of ways we can do it. One is that it's played in its entirety.
No,
and
these
then
are
you ask
pretrial
Detective
motions.
Jones to
Mr.
follow
Swinney
up.
is actually
And
going
have
to
you
trial
been able to
tomorrow.
locate these videos that Mr. Swinney was referring to? And Detective Jones says no. Mr. Westover seems to not like that approach.
It's suggesting to the jury that the defense claims that it's suggesting to the jury that the defense should be showing certain evidence, when that is never our obligation. It shifts the burden to us.
Okay. So I guess, do you know, I mean, when is the last time you watched this video? Do you know?
It's a CD, it's an audio call.
Okay. Alright.
I don't understand the reference to discovery since that was provided and this is not a hidden thing. So, but do I know exactly from the CD I can listen to all of it? To pinpoint that certainly, but again, I would step back and say that this is a partnership. It's the PA. It's not. There's no creation of. That's it. Why is that? Why is the state shifting the burden by playing this is the state?
Well, I mean, I guess, and I'm not saying that I'm persuaded one way or the other, but what I think Mr. Westover is saying is we don't have there's these videos that are referenced by Mr. Swinney. To the extent anyone's tried to find these videos, they are, as of yet, unlocated videos, and God knows if they were located tomorrow, there would be other issues anyway, to the extent that the jury then is like, well, yeah, where are those videos? I guess I can understand that it invites the jury to kind of speculate about these videos that we're never gonna see.
That's the jury instruction that says don't speculate. There are any number of things that a defendant may say in an interview, and that's where the defense attorney may come in and ask questions to cross-examine, the interviewer. This goes to the weight of the interview. I don't think it is any technical privilege.
But yeah, this trial was originally supposed to start either yesterday or today, and we've
Do you
just
have the
been far enough
timestamp
behind
of
that
I don't. It's early on. It's page 4 of my transcript.
that we're
It's the
not
first one that I,
even ready to
see.
start.
I'm happy to provide my entire transcript.
That would help.
Okay, read me again exactly what Detective Jones said.
So I have to go back a little bit. The Detective Jones question, we're talking about the 15th, and he says, what day of the week was that? About 1 in the afternoon downtown, right around 3 in Yamhill. Answer, yes sir. Yeah, I'm gonna get rid of all the ums and ahs and just read it through. The flag wave that we did on the 15th, that's correct. Detective Jones, okay. Answer, we went down to wave flags, and then we got to the Justice Center without incident. There were some people there that were waiting on us whenever we got there. We waved our flags, and it was really shortly after we got there that a few people tried to assault some people in our group. Detective Jones, Mr. Swinney, and they got maced as a result of that, and they even say on that video, that it's on video, that they came up and they, indiscernible, it's clearly seen on video that they were the aggressors.
And we don't think that that video is.
I haven't been able to find that.
How difficult is it to edit that out to be able to edit that invite the jury stuff?
If I have the transcript, then I can do it in a fairly reasonable amount of time. I'll just have to send it to the rest of
Mr. King, you can talk about
I have an email loaded up. I have notes on the
Okay.
transcript that I brought with me.
it. Fine. Email Mr. Vasquez.
I'm just going through it really quick. It's not that long. I don't see any other red highlighting in it. I sent them to Mr. Vasquez and Mr. Schweitzer.
All right. Next, Mr. Britton's speculation that the flag wavers were downtown to get some kind of media spectacle going.
Similar to my previous one about, anybody that was watching this would include speculation.
Mr. Britton going to testify
I will be
that he
right
thinks
back.
Mr. Swinney and his friends were downtown to get some kind of media spectacle.
I will. I'll talk to him about this and then ask him talk about it.
It's a direct quote from Randy.
State will instruct Mr. Britton not to speculate the reasons for the flag wave. Mr. Britton testifying that other members of Mr. Swinney's group had concealed weapons.
I will certainly talk to Mr. Britton about only the things that he was able to see on the day.
It's not relevant to any of the charges.
Well, Mr. Britton's personal observations of other people at the protest and what they did or did not have.
I'm back.
Does the state have a relevance theory for that, or are you going to tell him to only talk about what he saw Mr. Swinney have?
It depends on. I believe that the defense is going to be arguing self-defense, and so certainly what the other people have to come up with, and Mr. King's group maybe relevant to that discussion. Because there's a different analysis of, hey, I'm walking down the street by myself, or am I walking down the street with 10 of my friends, and they are armed with swords, batons, and paintball guns. There's a massive difference there in the self-defense analysis.
Reasonable belief is what we have to do, not whether the other person was in any way acting unlawfully. So if there's an effort to explain somebody's behavior because they think of something else, then you end up talking out of the end on the scene. And essentially talking about the lawfulness of
I would say also those things that she's the professor. I mean, there's evidence that he walked these people down together, and he's not going to teach up, and they come down, and the witnesses will testify that they were armed. The video would show they were all armed. And the analysis of is he acting reasonable? Let's take it from this out of the context perspective. If one man walks up to a group of 5 other employees and we're all armed, that's relevant into a self-defense analysis. If they all know, like if the 5 men are standing there and they all know, like, I know Mr. Schweitzer holding a shotgun and this person is holding a baseball bat. It's relevant to that self-defense analysis. And was it reasonable? Was there provocation, initial aggressor, things like that?
So I'm, I guess, stuck on this question of concealed weapons versus.
Yeah, I'll tell him to only talk about what he saw. Like, don't speculate. Did someone have a concealed handgun, or did someone have a knife in their pocket? Like, you didn't see that. That's not an issue. These are very overt things. Like,
right.
Literally, there's a guy carrying a 5-foot-long sword walking next to Mr. Swinney and a giant shield. These are the things we're talking about.
Right, and they're going to be on video.
Yes.
Yeah, this is a lot of what's been going over on both sides.
The videos I've seen, yeah.
Is
And
they,
so
they
Mr.
want to
Britton
focus
says, like,
only
and I
on
saw a
what
dude with a
happened with the people
long
that
sword,
were
too. You're gonna cross,
victims or
Many
alleged
times.
perpetrators.
right?
They want to try to avoid what were the crowds doing.
So I don't think speculating about concealed weapons is appropriate because I think it's speculation. But what a victim or a state's witness observed that is going to also be on video, etc., I think that's probably fine.
And that's fine, you're right. Happy.
All right. Jason Britton testifying as to his opinion that they did not come down for an innocent flag wave.
I certainly won't be asking him for his opinion about the flag.
Okay, then it doesn't sound like you are contesting this information and that you instead agree that that is not true. Jason Britton testifying that to anybody watching, it was pretty clear that Mr. Swinney was there to antagonize.
I think in this area, it's not so much I certainly wouldn't. I can advise him to say. It becomes more a matter of the manner in which he speaks. It's not so much a question. I'm not going to ask him, well, if anyone was watching this, what would they think? I would ask him, when he's speaking, it's things like, it was clear to me that Swinney was antagonizing. I would certainly talk to him in English and say, don't say things like, anybody watching, just talk about what you saw, what your perception was. His perception was that Mr. Swinney was antagonizing. Well, then you should be able to testify.
It's just a direct quote from Judge.
So I don't think that Mr. Britton should assume that to anybody watching it was clear Mr. Swinney was there to antagonize, but if Mr. Britton has the opinion based on what he observed, Mr. Britton can testify as his layperson's opinion about that. Jason Britton testifying that Alan Swinney was faking distress as an excuse to give justification to spray a guy in a wheelchair with me.
I believe this is in reference to, there was a moment in the video where there was some discussion about this gentleman in a wheelchair being sprayed with mace. I'll ask him to not talk about faking distress to spray a guy.
Any testimony that Alan Swinney's paintballs were anything but regular, non-frozen paintballs fired at the regular/factor setting from his paintball gun.
I just think that based on the evidence that they have, there is video of Alan Swinney holding a paintball, shooting a paintball, shooting a paintball. There's no, for the ballistics of the things that are coming out, content of the things that are coming out, that rises to a level where Brown or Key scientific opinion, expert opinion.
I think what would happen is Mr. Griffin will talk about that he has been paintballing or he knows to go back and it's just a that's what he does. Does he know that they were frozen? I would say no, and I'll ask him to speculate about it, but he would just testify this is that. There were paintballs that were fired at Parker. And so that's why even the Stanley Jorgensen discovery it has some of that information. I'm referring to Detective Cochran's report. I'm not calling Detective Cochran. I'm not calling to seek witnesses. I'm still not being shot by people.
So, I mean, I think if Mr. Britton says he's been paintball shooting before, something about this felt different, but he can't put his finger on it. I mean, that's his layperson's opinion based on his experience as someone who's, shot and been shot by paintballs before. Speculating as to what was different about the paintballs, that he thinks maybe they were frozen or thinks maybe the regular/factor setting from the paintball gun was set differently, or that some were harder than others. I don't think that that's probably appropriate because I don't even know how you would know that. But I admit, I'm not an expert.
I've been paintballing once. I know how to explain that.
I don't see anything about the different paintballs. The only thing I see about paintballs is somebody named Andrew Simmons who was detected Dr. Simmons and his associate Jason Britton walked in the area of Southwest Fort Island, Union Street, on the counter protest began shooting people all affected after Jason was shot.
So the Jurgensen person, or whatever his name is on the case witness list, and he was the one who you said would conceivably have testified about that?
No, he was a co-defendant, not co-defendant. He was with Mr. Swinney that day, and he was already been prosecuted.
Okay. And you're not introducing his statements.
Nope.
Okay. So it doesn't even sound like that.
I think this.
I mean, the point is there's not anything in discovery other than speculation that Jason's written about there being different kinds of people.
I'll ask him to really discuss the issue. It's a non-issue, but I'll ask him.
Yeah, and like you said, Megan, in Britain's case, usually when you're paintballing, you have
testifying about
good
the
eye protection.
conclusions his eye doctor made, and as to statements they made to him, I feel like we already kind of discussed that. Yeah?
Yeah, I think we did. I do think we also skipped number 20.
Well, I kind of thought that was, so Jason Britton testifying about how different kind of paintballs break. I feel like that just goes back, I mean, I guess I kind of thought of it as 19 and 20 being sort of the same.
Okay.
I mean, he has experience with paintball.
Not getting hit in the eye. You know when you ever hit in the eye once? It was this thing.
Okay. What does that have to do with how different kinds of paintballs?
Because he described how it sort of cologned off of his face and how it would be different for different kinds of paintballs.
Well, I mean, I'll say this. Someone who has been paintballing and has experienced it and been involved, sometimes paintballs break and sometimes they don't. It doesn't mean that they're not a paintball. It just means that sometimes they hit you and it gives a different sensation because it doesn't actually break. That's what he's referring to, I believe. And so if he's able to testify and say, that's my experience is that sometimes they don't break and it hurts. I don't see the harm in that, really. It's his experience, his perception.
I mean, I think as long as he doesn't say, like, therefore, I have assumed it was frozen and or some sort of altered special paintball.
There's two different kinds of paintball. Paintball with paint in it, and then there's another kind of paintball called a rubber reball. One of them is called a reball because it's reusable.
Okay.
Jason Britton testified at grand jury that rubber reballs cause more damage. They're designed for a different type. He's not quite right, but he talks about these different kinds of things. I don't want him to say. I don't think he can say that it was a rubber reball.
I'll ask him what he's basing his knowledge upon. When I discuss it with that out of court, if it's purely just speculating there's a reball, then I'll tell him this gets only shot by a paintball.
And it is not right.
Don't speculate.
Yeah. A lot of this could just be sorted out if the two of them would talk.
And to the extent that Mr. Britton is willing to talk to Mr. Westover ahead of time and explain what he intends to say, that may make things go more quickly. Okay. So 21, we're fine. 22, we're in agreement. 22. Brittany, Carol, or anybody testifying about people having screws coming out of their shields.
Oh, I remember hearing that rumor.
It's the same thing. I mean, she's
Basically making spiked shields.
people that are in the crowd that are associated with Alan Swinney, but it has nothing to do with Alan Swinney's conduct. Alan Swinney does not have a shield.
Are there videos of people's shields with screws coming out of them?
There are, and there's a video of Mr. Allen Sweet standing basically over the top using the shields as a barrier so that he's able to shoot other people. There's that.
So, and Brittany Carroll is a witness, but was on the scene at the time.
On the 22nd.
Okay. And her perception is that the shield had screws.
Yes.
He's seen holding one of those.
No, I'm not holding it. He's standing behind a line of people,
Okay.
have them, and
I think that is relevant evidence. I think that Brittany Carroll's perception is that. Brittany Carroll or anybody testifying about Alan Swinney posting, quote, hate speech on social media.
I'm not. Yeah, I think we said that we're not going to do. We really not putting this in direct. Yeah.
entering in on direct exam. And last, Megan Stewart testifying that paintball may have been hurt.
We will not be bringing in that testimony on direct.
All right. Okay. Is the next thing we need to take up the self-defense issue?
The state's motion?
Yes.
State would like to.
Is that the state's motion in limine to exclude unrelated other acts evidence?
Yes. And it relies on the Supreme Court. What is, I guess, and so, I mean, I think what I need to understand probably a little bit is, let me take a step back. In order to evaluate my legal position on this, I have to understand both the subjective belief of Mr. Swinney as well as whether or not that was fair to a reasonable person, and whether or not some of this stuff comes in. Do we agree that that is the state of the law? And so, understanding that things may or may not change as the trial goes on, how would
My memory's a little more
evidence
faulty.
of an incident from another protest be coming in?
So, a couple of things. We're talking about August 15th.
Okay.
There's a man named Andrew Duncan who's present on one of the videos.
Okay.
He is walking close to the standing with Mr. Swinney during this. On his chest, there's tape, white tape, and on the tape is written, "Do not stab." Earlier on a video, there is a back and forth between the folks that are following Mr. Swinney's group, as well as and talking about, you guys do violent things, you guys do violent things, that sort of thing. And one person turns around and says to one of the pursuers, they're talking about Andrew Duncan, saying he got stabbed a few weeks ago. I think that there is an inference that can be drawn that Alan may be close proximity with Andrew Duncan for that thing on his chest saying "do not stab." It is an inference that Alan may be about. It may go to wait, but if I see somebody, if I see somebody with a colleague of mine with a sign on their chest that says "Do not stab," I'm saying, "What's that all about?"
Uh-huh.
And then they would tell me who that was. So I think that would also be if we're talking about the reasonableness.
It's crazy how much stuff feels like it's common sense, but because it's legal stuff, they have to be very careful.
I think it. Here's the thing I'm stuck on right now. I don't know. The evidence is not before this court right now. The timing of Mr. Swinney potentially talking, if you did talk to Mr. Duncan, I don't know. I don't know if you talked to him. I don't know when.
Yeah, we don't know who the defense's
the fact that
witnesses
in the
are at
middle
all.
of all
They're
of
under a
this,
court order.
There is some colloquy that is
And I
heard
suspect
on a video
Duncan, from what I'm hearing,
that
would be
Mr.
one of the
Swinney is a
witnesses
part
they're more
of in the
likely to
midst
try
of
to get.
I'm assuming, though I haven't seen it, chaotic scene. That information I don't believe is sufficient to say that it comes in as part of what has formed Mr. Swinney's subjective belief that he needs to defend himself or others. What am I missing?
We're talking about.
Yes, I have a big water dispenser
I think
right
that
next
if
to my desk.
Mr. Swinney were to take a stand in this case, and if he were to testify, Andrew Duncan told me that he got stabbed, by Antifa 2 weeks before at one of these events, then that would adequately lay the foundation for knowledge as it relates to his self-defense claim. I don't know if Alan's going to testify or
Okay.
not, but I think we would get there. But I think we're talking right now about foundational issues. The state's seeking to exclude it entirely, even if a proper foundation is laid, by saying that it's not that knowledge is not relevant, and Strickland is very easily distinguishable.
I actually agree. I think Strickland is distinguishable. So, I mean, I guess I'll say this. If Mr. Swinney takes the stand and he testifies that he knew, I think that does come in. Why am I wrong?
So, Judge, there's a number of problems with the defense theory of why this is. There's also problems with the foundation that they've described, but we don't need to get into that, because even if they lay the foundation, the problems are that, and this goes back to the discussion we were having earlier about Mr. Swinney's parlor posts, and what was at that point the defense argument that what that would be to affect, what the purpose of putting forward this, my buddy got stabbed on a date prior, would be to, so the jury can infer, therefore Antifa is violent generally, that this group, because they are leftists, are therefore also violent, and because the victims in this case were part of that leftist rally, they must also be violent. That's part of the problem that, again, this is being argued essentially on the flip side by the defense. That's a problem.
And they lost a lot of that.
Well, again, the direct reference that has to be drawn is that it's because there were violent people at a different but similar rally before, this one must also be. It would be different if, it would be admittedly different if Mr. Duncombe, or testifying by hearsay about Mr. Duncombe's incident, said that guy in the crowd standing next to Jason Britton is the guy that stabbed Anthony. That would be potentially in that world of evidence that would be relevant to Mr. Swinney's state of mind, why he would be concerned and would need to defend himself.
I feel that is all fertile ground for cross-examination of Mr. Swinney.
But that, I mean, that would be true of the evidence in Strickland, excuse me. That would be true in Strickland too. I mean, the state could have cross-examined the defendant on that point as well.
Okay, well, Strickland, let's be clear. Yes. What Judge Ryan, ruled in Strickland was that Mr. Strickland pulling a gun at a protest, ostensibly in self-defense, that
My understanding is Strickland is a case that happened right in this same area geographically at the Justice Center.
When I was at a restaurant taping some dude, he got mad at me and beat me up or broke my arm or whatever. That's a very different, for two reasons. It was a year ago. It was one person. It was at a restaurant. Here, I actually think if it was, and 2 weeks earlier at the protest involving similar characters of people, I got my arm broken with my camera, and that's why I brought my gun the second time. I don't know that I think Judge Ryan would have excluded that.
But I think that's a difference without a distinction. Just because that was part of Judge Ryan's analysis doesn't mean that if those factors aren't present, that changes the analysis here. There still are significant differences in this circumstance involving. Those distinctions, again, require the differences highlight why it does not advance an argument that Mr. Swinney's, if he did in fact perceive a threat, was reasonable. That's part of the court's analysis. The defense does not get to bring in every single thing that made him perceive a threat. It has to be reasonable. That's, I think, the heart of Strickland, is the defendant does not get to bring in every prior incident or every fact that caused him to perceive a threat. It has to be related to why a threat was reasonable.
and I just don't think that's what Strickland says. I think that in certain, what we're talking really is relevance. And what Strickland has is, based upon the facts that we're talking about, as Your Honor identified, a year ago, a completely different group of people in a completely different situation. The ruling essentially there said that just doesn't get over 401. It's not logically relevant. And Strickland has language that seems to look bad, but you actually read the case for what it says, and it talks about exactly what you're saying. It distinguishes it. So this was not a case that, it was similar parties or along those lines. And I guess the last thing I'll say about that is, I don't understand how the state's been moving to introduce all of these other statements of Mr. Swinney for the purpose of rebutting self-defense, and now they're saying that it's a two-faced argument.
The biggest issue here is that the defense argument and their theory of law is true. And that opens the door to every piece of news or rumors that Mr. Swinney might have heard. Hey, people have guns at these rallies. People are going to, hurt us at this rally. It would open the door so widely. And again, when we're looking at a self-defense argument, we have to be specific about threats and then about the evidence towards those threats. In order for the defendant to prevail on the self-defense, he has to make the argument that the threats of the people, his actions are necessary because of threats relating to the people that he harmed. And so saying that a guy got stabbed 2 weeks earlier, who by all accounts was not at this event, and was not present near or anywhere in the vicinity of Mr. Britton, it's so far afield from the circumstances of this case that it requires, essentially it's going to just be asking the jury to say, hey, there were violent people at a previous protest, which means there were probably violent people at this protest, which is absolutely propensity evidence about a whole class of people that attend protests. And it would ask the jury to then use that propensity evidence, again, to apply that to a whole group of people that showed up on these particular days, and that somehow that makes it reasonable for Mr. Swinney to start attacking random people.
I think that goes to the weight of the evidence, not the admissibility of the evidence. I will say, I think the only way that it comes in is if Mr. Swinney himself testifies to his personal knowledge of it. And so, to the extent that there is reference made and Mr. Swinney decides ultimately not to take the stand, there's going to be some real limiting instructions given to the jury about how they have to disregard everything that they've heard. I don't disagree entirely with the state about the problems with the evidence, but I feel like it's subject to the cross-examination of Mr. Swinney, and it's going to be subject to probably a limiting instruction.
Yeah.
And so
there's just too much we don't know.
And I also don't agree with the state that it opens the door to everything else. I think it opens the door if he testifies he had personal knowledge that Mr. Duncan had been stabbed 2 weeks earlier and that had him more on edge. I think we have to allow him to pursue self-defense.
I have to say, from what I've seen in this case so far, it feels like the defense is just going to have to
I would say, depending on
try to weaken the ability for the state to make an argument,
so I'm just saying, I don't know
as
that
well
for sure, 'cause I don't know
as
exactly how it's
just
all gonna
throwing
come
everything
out,
else
but
at the
I'm
wall and see what
just,
sticks.
I'm not going to, I don't want there to be a lot of, sad cases if I start letting additional parlor posts in once the door gets open. I don't know what's going to happen. But.
Oh. I think she's one of the defense. Yeah. He probably doesn't want to take that chance now because.
Yes, you are, but go ahead.
It's
truthfully,
pulling
Okay.
together
So the second piece of the
extra
state
parlor
motion
posts
was
is not
only
gonna
Mr. Duncan,
help his
but
defense.
but evidence of separate acts by essentially random members of the large group or groups that assembled on the 22nd of the 15th. I think we have a little more sense of what the defense intends to introduce with that. We have the 5 videos that they announced that are likely exhibits or potential exhibits. In those, there are at least a couple videos that show. It's a little bit difficult to tell exactly what's happening, but at least a couple of incidents where they're showing people on the groups opposed to Mr. Swinney's group, with there's some kind of bag of, I'm not sure what, but they're kind of hiding it, and then there's an interaction with the person who's taking the video. This happens well away from where Mr. Swinney was during the event. It happens essentially again on the side opposing Mr. Swinney's group. The camera angle makes it clear that he's not with the cameraman to see what's happening. And similarly, there's another video that
would
shows
question
a
admissibility.
guy, again, not clear who he's affiliated with, but appears to be opposing Mr. Swinney's group, holding a knife for approximately 20 seconds. So, again, having a interaction
Okay,
with other
just
people
keep
Mr.
in
Swinney's
mind
group.
they
And in
may
that
not
video
be able to
particularly,
use it.
About 50 seconds later, that clearly that Mr. Swinney was some distance away in an entirely different part of the, that strip of in front of the justice. So, again, with evidence like that the defense might intend to introduce for the purpose of advancing the self-defense argument. As the court noted with the Duncan issue, if Mr. Swinney's not there, doesn't see that, doesn't perceive those things, those potential threats, it's not relevant to their self-defense argument or the case more broadly, and it would be prejudicial under 403 analysis, because again, it invites the jury to say, oh, that entire group, whether Mr. Swinney was aware of it or not, is violent, and therefore had it coming, or something to that.
Okay. Do you disagree with that?
Yes.
Okay, what?
Alan's account to the detective is describing all of these things, particularly on the 25th. People were throwing things, people on the other side were engaging in acts of violence, not just to him, but to members of his group. And to the extent, what those videos show is the scene. It shows the scene that there are rocks being thrown by the other side and people forming aggressive, I don't know, phalanx-style shield walls against the people that...
Wait, shield wall is the normal term for it.
It provides context for the scene, which there's going to be not just the defense itself, but there's defense of others as well, and it goes to the reasonableness of the belief that provides corroborating information that these are the types of things that we see.
Okay, here's where I'm landing. And then it's 4:30.
It is.
What Mr. Swinney
Oh,
learned
4:30,
after the fact
Mr. Swinney has
by
to
watching
leave,
videos is
or
not
else he
relevant to his
risks
objective
having to get held at
So
Justice
to the
Center
extent
for a
that
few
things are
hours.
occurring outside of his presence, even if they are on video, those are not relevant. So at least the 2 examples that the state gave, I agree, would not come in. If Mr. Swinney testifies that he had a rock thrown at him by someone in the crowd, then Mr. Swinney can testify to that. But he can't say, and then I saw a video from earlier, or my buddies told me that there were rocks being thrown at them down the street from where I was. That's not relevant.
There's at all, a depiction of a violent scene that Mr. Swinney is very clearly at, and there's no
He does not want to lose this one.
The fact that he didn't see this specific rock that was being thrown doesn't provide corroboration of his account that there's a violent mob attacking him. And
They're
so-
not attacking him. They're attacking other people.
and he is, with the defense of others, is
But he doesn't get to say, I was defending every single person within a 2-block radius. Defense of others is the people that are right there with him that he thinks he needs to defend. Not that he's some sort of super soldier who's gonna fly with his, body armor
It's
down
like
his
I said
face.
before.
really,
She's got a really good personality,
perhaps you're
and she seems very tough and fair, and
I mean,
I like this judge.
it's absolutely relevant. If anything, what we're talking about is him asking that he's talking about other acts evidence, and there's very clearly an other acts evidence exception that allows information to come in, providing context and necessary background information. So to the extent that we can corroborate that this is a chaotic situation where items are being thrown into the crowd that Alan Swinney is in, and essentially the circumstances of what happened are there was a Back the Blue rally that was in front of the Justice Center. A Antifa group started showing up on the other side, and things started to be thrown. It will then be shown that Alan Swinney and the people that he was with stood in between the folks who were waving the flags and the folks that were throwing urine, frozen water bottles, chunks of concrete, golf balls.
I think she's my favorite judge I've
shooting
dealt with
projectiles
yet.
in, and it absolutely is defense of others if you get in between a group that is seeking to do damage to the people behind it.
What I heard the characterization of the evidence is that Mr. Swinney was not within the area to perceive the particular evidence that the state characterized. That there's a knife and Mr. Swinney is not there. That there's people looking in a bag and Mr. Swinney is not there. If Mr. Swinney was not present to perceive the threat, then he can't have that evidence.
Exactly,
I mean,
Meg.
it's the same thing
And then
as saying,
if it wasn't you, he would
it's
have ended
not
up
fair
hitting
to
someone
Mr.
else.
Swinney that Jason Britton says
It's still an assault. Being a bad shot doesn't. Oh God, no! I've seen
those are on video.
some of the stuff he
shields are on
says.
video, and Mr. Swinney is within the proximity of them. That's what about it.
There's no evidence that Alan's on the video that Alan Swinney actually looks at the shield. We want the information from these incidents to come in. We don't want the state to whitewash the violence that was occurring down there against the group that Alan Swinney was a part of.
Are any of the videos of the actual people getting? I mean, that's all coming in, right?
Well, the state's theory of the unlawful use of the weapon is he's committing the crime the entire time he's down there, and they won't name an individual person. So yes.
Well, the difference is this: the state's going to present videos, and they're videos that either Mr. Sweeney's in, or where the witness or the victim's in. That's the difference. We're not presenting, because it takes a place of a block, right? And we're talking about Mr. Sweeney's action. So if he's down on one side of the block, and then on the other side of the block there's a guy standing with a knife, why does that come into his subjective and what he?
It doesn't.
That's the issue. That's what the state's looking for.
It doesn't. If Mr. Swinney testifies that he saw a knife, that's coming in. And if the video corroborates it, that can come in. But if Mr. Swinney didn't see a knife from what I am hearing is hundreds of feet away in a crowded, chaotic scene, I don't think that's right.
I think you're gonna have to watch that.
Okay, I'll see you guys at 8:30 tomorrow morning and we can watch the videos. I'll try and get Swiss to reflect 8:30 from
The Swiss is just one of the jail systems.
So I received the disc from People's Council today with the videos. I put them on my computer so I can be able to grab the disc problem with the court's computers is an issue.
Probably the same disc problem that Mr. Keeney experienced when he had this idea.
Can we email something?
Do you object to him emailing me the video so I can watch it tonight? All right, if you can figure out a way, even up to and including, like if you can put them in a Dropbox that I can download on my personal home computer, then I won't be in violation of the judicial department rules.
They are on the record.
I don't even know that we have anything that places
Or that.
And Your Honor, before we go off the record, just I wanted to make it abundantly clear that I'm particularly concerned about this. I understand the that has absolutely experienced in instructing the on and what's and what's not actually allowed by Your Honor. But Mr. Britton's testimony both as on the video and then on the jury and the police officer, I would like to put the state on notice that we will be asking for a mistrial if any of that comes in. And asking him the question is not asking him the question is very different from the witness being told that if they decide to just not follow the question and just go ahead and go off script, that we will be asking.
And this is the issue I have, is this kind of gotcha game. I will talk to the witness. I will explain to him that these are the areas that we discuss in court, and this is what you're not going to say. He's an animated character. He is. I'm not going to direct him or ask him questions for what the court's rules were, but this is this.
I understand. Make it clear to him that he would be risking the entire case if he says it, and if he does it anyway, we'll figure out how to deal with it.
Thank you.
See you all tomorrow at 8:30 a.m.
Mainly because the case law on this route is terrible, and the whole idea of limiting instruction absolutely.
No disc right, man.
Do you have a couple?
Maybe you have a Dropbox?
Okay.
So just email me once you have figured out.
Yeah, so that's where we're at now. Oh, they kicked the chat. Okay, so yeah, we're done with court for today. It sounds like the motions that we just heard, they're going to revisit early tomorrow at 8:30 with the jury showing up at 9 and probably being ready to start the opening arguments by about 9:30. I will set my alarm to get up earlier tomorrow to be ready for 8:30. I don't know if they're going to stream it to make it available or if they're going to wait until the jury comes in. So yeah, we'll keep an eye out. Whatever platform you're watching on, just go ahead and subscribe so you can get notifications when we go live. I'll also have updates that go out on Twitter. Links to all that stuff should be down in the video